gambangako ku kintu kyonna era kkooti ne bebanga eyagala okufuna kujuza obusingawo awo kumafa prison bwegali. Ensonga ey'okubiri ekitiibwa omulamuzi, waliwo tusuubiza okutuwaka ku ruling ya submission ya no case to answer nze ne lawyer oyo, naye simanyi oba ye wagimuwa naye nze sinnagifuna. Ensonga ey'okusatu ekitiibwa omulamuzi, nsaba kkooti ekitiibwa omulamuzi emanye kubanga omwami oyo Kalyango tuli ffenna wano mu ddooko tusobola obbanga kkooti egenda mu maaso natandikirawo era okukuba enduulu n'agamba nti mugambye ebigambo by'okumutta. Nsaba kkooti omulamuzi benga ekimanyi ekyo kubanga ekigenderwa kyabwe kinene n'oludda oluwaabi. Namwe ekitiibwa omulamuzi bwe kibeera nga kisoboka nga si kulagira ala bwe kiba nga kisoboka ekitiibwa omulamuzi, kkooti bwe beesobola okufuna weemuteeka oba nze ne bafuna we banteeka oba si kyo ne balagira ku bakama baffe bana ba prison, oba najja n'abeerawo awo mwaneeno ng'aba asobola okujulira. Kyembadde nsaba kkooti ekitiibwa omulamuzi zezo ensonga zange, naye ng'esooka eri ane nsaba ekitiibwa omulamuzi eteekebwe ku likodi nti nze simugambangako, eteekebwe ku likodi y'omusango guno tesimugambangako. Yes, era ekitiibwa omulamuzi omulala ne bwabe ekitiibwa omulamuzi ensonga yange esooka egamba Kalyango Nasifu Alliance Muwonge, Alliance Muwonge.
Yes, my lord. My brother, Counsel Jonathan Mwaganya, raised a matter which is within the ambit of the administration of justice, which is within the ambit of the interest of the administration of justice. That matter, my lord, is in line with the joint representation. That matter is in light with the joint representation of A2 to A6, and it arose from the evidence as given by A3 in chief, by A3 in examination in chief. My lord, it is clear that in lieu of the testimony of A3 in chief, in lieu of the testimony of A3 in chief, there is a contradiction between his evidence and that was given by A2. There is a contradiction of his evidence as against that was given by A2. My lord, we have interacted, myself and Counsel Mwaganya have interacted with counsel that is representing the accused persons, save for A1, and it appears to him that the testimony of A3 took him by surprise. This testimony of A3 took him by surprise, as he didn't predict what he was going to say, as he had different instructions from A3. As he had different instructions. So to avoid prejudice of the defense counsel, and the accused persons. It is our humble suggestion that a decision be made for a new council to be appointed to represent one of the accused persons. My Lord, Counsel Sewambala, having read fully the evidence of A2, that is in chief and examination and re-examination, we suggest that he remains to represent A2, whose evidence he has read fully and instructions he has exercised fully. And the new council be appointed for A3.
He remains what?
He remains to represent A2, having executed full instructions for him. And the new council be appointed for A3. And my Lord, in the interest of justice, it is safe that the evidence that was given by A3 be expunged from court record to enable counsel for A2 to cross-examine, to test the evidence of A3.
Given by A2 be expunged.
Be expunged from A3, I beg your pardon, A3, be expunged, so as to enable counsel for A2 to test and cross-examine the evidence of A3. My Lord, it's also prudent at this stage that Counsel Serwambala and any other appointed attorney be given the liberty, the facilities to re-interview their clients. My Lord, just, okay, be given facilities to enable the new counsel to prepare for the case.
You know how we do your work. Once you raise your point, we just continue.
Most obliged, my
You
Lord.
don't give me the details.
Most obliged, my Lord. So, my Lord, that is our humble
Mr.
prayer.
Chairman, that's very sense. Well, actually, it should be the one telling us most of what you are saying.
Yes, my Lord, I am surprised that the state knows a lot about the defense's case. My Lord, at the beginning of the trial, the advocates for the defense are appointed by the clients.
At the beginning of
The
the
trial, the advocates for the defense, for the accused persons, are appointed by the accused persons. The accused persons have the right,
appointed by the accused person.
yes, my Lord, the accused persons have the right to deny or to refuse to take up a lawyer,
How?
a right to refuse to take up a lawyer who has been provided by the state. In this case, my Lord, one of the accused persons exercised that right.
It's been provided.
My Lord, the accused persons also,
In this case, one of the accused.
in this case, one of the accused persons exercised that right and refused to be represented by the lawyers provided by the state. My Lord, the accused persons also have a right to appoint independent counsel. My Lord, defense lawyer, defense. My Lord, an advocate works on behalf and on the instructions of the client. My Lord, the land state attorney has not cited any law which is to the effect that a defense lawyer cannot represent several accused persons. My Lord, My Lord, a defense counsel cannot predict what evidence the accused person will give in court. And
What evidence?
what evidence the accused person will bring up in court. And for that matter, my Lord, defense counsel is prohibited from coaching the accused on what to say. Therefore, my Lord, it is my submission that incriminating evidence or non-incriminating evidence brought up by the trial or non-incriminating evidence brought up at the trial by any of the accused persons is not a surprise and is not proof of change of instructions. My Lord, it is a treaty law that prejudice should not only be mentioned, but prejudice should be proved. My Lord, I have had a discussion with A3 this morning, and I have explained to A3 the complaints of the prosecution and A3 has advised me that there was an error in the last proceedings whereby his evidence in chief was not complete. In the proceedings whereby he misunderstood the question that I asked him, that is that all you have to say? That he thought that question meant all about what he was specifically saying, but not all about his giving. All about what he was specifically saying.
Is that all you?
Yes, he misunderstood the question that I asked him.
That what?
That is that all you have to say? Whereby he misunderstood the question, that it meant what he was specifically talking about, but not closing his case.
Whereby he misunderstood?
He misunderstood the question, that it asked about what he was specifically telling court, but not a closure of his evidence in his defense evidence. A3 has requested me therefore that since cross-examination is not done, his account is still continuing, he would like to give more evidence. A3. That he had not completed giving his evidence. My Lord, in conclusion, it is my prayer that A3 be allowed to continue with his testimony until he tells this court that he has finished giving all his defense evidence. It is my prayer.
Continue.
Yes.
His evidence until
He finishes giving all his defense evidence. My Lord, my last prayer is that this honorable court be pleased to ask specifically A3 on whether or not he wants to continue my counsel, since he is the appointing authority. I so pray. I pray, my Lord, that the accused person be translated to the proceedings of this court.
Firstly, I need to notify court that the appointment of counsel on state brief is not at the behest of the accused person. He does not determine who represents him. It is court that appoints. So it's not a correct position of law or practice that the accused person appoints for himself counsel on state brief. My Lord, why court appoints is because court has to take in consideration the administration of justice, as the accused person is not technical enough to appreciate matters of the law. My Lord, there is a wealth of authority to govern the issue of joint representation. I pray to refer this honorable court to the case of Kyla. Kyla, my Lord, is CU
the issue
of joint representation. I pray to refer this honorable court to the case of Kyla. Kyla is CUYLER versus Sullivan. Sullivan is SULLIVAN. It is case number 446 of the U.S. Supreme Court 335 of 1980. My Lord, in that case, in page number 10, paragraph 2, among others, it was said that defense counsel has the ethical obligation. Defense counsel has the ethical obligation to avoid conflicting representations. Ethical obligation to avoid conflicting representations. And advise the court promptly when a conflict of interest arises during the course of the trial. And advise court promptly when a conflict of interest arises during the trial. My Lord, in the same case, in the third last paragraph, the court stated that an attorney representing two defendants in a criminal matter is in the best position professionally and ethically to determine when a conflict of interest exists or will probably develop in the course of the trial. My Lord, I'll not go into the evidence as has been demonstrated in this court because it's on record. There is no doubt that a conflict in the evidence of A2 and A3 exists. There is no doubt that a conflict of the evidence a conflict in the evidence of A2 and A3 exists, and it is the ethical and professional mandate of defense counsel to bring it to the attention of court. Fortunately or unfortunately, in this instance, it is the prosecutor bringing it. Why? Because, my Lord, under the Constitution of the Republic of Uganda, Article 120, Clause 5, it says, in the exercise of his or her mandate, the Director of Public Prosecution shall bear in mind 1. Public interest. 2. The interest in the administration of criminal justice. 3. The need to prevent abuse of legal process. My Lord, in respect to that constitutional provision, in the interest of the administration of justice, Article 120, Clause 5. In the interest of the administration of justice and in the need to prevent abuse of legal process, where a conflict has clearly shown itself, my Lord, we pray that this honorable court takes charge of the proceedings. It cannot be left at the hands of the accused person who knows nothing about the law. Totally nothing about the law. And at the hands of defense counsel who has sat on his ethical and professional obligation.
Since there is a problem here, you say that he wants now to add
that ought to advise the accused on the proper position. Okay. I do not know why counsel has a behest on saying, does counsel himself have a problem with the prayer that I am making? I need to know it from him. And let it be so. And let the new counsel be appointed for Kariam. Because we cannot see this case fail just because of...
Kariam, where is Kariam? Yeah, we discussed with your lawyer. They are saying, in your evidence, you're implicating A2, yet you are both represented by the same lawyer. because that will not be good, because the same lawyer who is defending you in a particular way cannot come and again defend another person against whom you are giving evidence. So in our profession, that would be wrong, and it would mean that that lawyer will stop representing one of you. But since he had already finished representing the other, it is you who is in the process, who is still in the process of being represented. Do you have, and now they say you even want to add some evidence. I don't know which evidence. So, why wouldn't we get you another lawyer continue representing you? Because this one actually, the lawyer has represented you, is already here on record. Now if another
wa gavumenti nekulira wano bali kutunulira obujulizi obukontana kulira wano asoose kutegeeza kooti nti obujulizi bwo kino teyekisuubira kuba nti kijja kubeera bwekityo wabula n'agamba nti okulira wa gavumenti n'ategeeza kooti nti ekyoka kigenda mu maaso bayogeddemuuko kulira wa gavumenti nekulira wamwe bwe namba bwe kalyango nomundo namba 2 okuba nti bulido oli bukulese bambala yakiikiriramu munna naye ate nga tonaba obujulizi bwe waleeta ate bulumiriza ono munnonge mu bunaanibwa omusango okunkola eyo kitegeeza nti bulido ono tasobola ate kuwolereza abantu ba mirundi 2 mbeera eyo niwajjawo nti mu nkola ya kooti kiba tekiwa makulu ekiyinza okukolebwa okuba nti wabeerawo bulido omulala akiikirira nga mwawukana mu bapulido mu kukiikirira Leader wa gavumenti obwedda kyawaba kati kooti oyingiramu era nekubuuza nakati naawe kenyini akakusinzira ku leader wagambye nti walinga owobujulizi agamba nti osaba kooti ekuba omukisa ogende mu maaso n'okumalayo obujulizi bwo so nga te kooti yali ekimanyi nti ogaddewo obujulizi bwo kati mumbeera eyo kooti okwekenneenya byonna nti okuteekawo omwagaanya omutuufu obutakugira nkola ya musangiro okuba nti wabeerawo obwenkanya tekiba kyamagezi liida omu okukiikirira abantu ababiri naye nga ate abantu ababiri abo mubujulizi bwabwe obwomu bukontana n'obwomulala kati ekibuuzo ekikubuuzibwa ati olina ensonga yonna egaana okuba nti bakufunira kuliida omulala
sirina nsonga egaana looyo omulala naye ensonga yange eri nti nze mbadde njagala oba bankyusiriza looyo mbadde nze njagala nsigaza oyo abadde bwe mbadde naye omukadde
the other is Nawire, but Nawire is not here and she has a problem. That's why she has not come today. Do you have any problem with Mr. Sewanga continuing to represent you? He can choose whether for you to testify again or whatever, because now it is his place in case he takes over. It's not us to decide for him on how he's going to represent you. It will be him after talking to you. Do you have an objection to Mr. Sewanga representing you? Sewanga? Geoffrey?
Bakulida abakiikirira abantu kati nga mu kooti eno bali basatu tulina mukulu Sewambala abadde akukiikirira kibeera ne mukulu Sewanga yamudiridde n'omukyalo omulala Nabwiri taliyo wano alina obuzibu bwe ensonga lwaki taliyo wano kati kubala ababiri olw'ennono ye abakikuddemu okusayirira tusigaze oli mukulu Sewanga kibuuzo ekikubuuzibwa olina ensonga yonna egaana mukulu Sewanga okukiikirira mu musango guno ekirala kyayongeddeko kooti kyeyongeddeko nti bw'oba mumaze okukkaanya nga tokirina buzibu okukiikirira kati kitegeeza yakutte seringi waddemba okwogerezaganyamu naawe kati okusaba kuli ono gwe yeyogeddeko nti oyagalaku olina obujulizi bw'oyagala okwongerako kigeri liidawo ayinza okusala okwekyo oba ayinza tosalawo nti oddemu bupya obujulizi kubanga aba yakajja ku seringi y'omusanvu
record of proceeding, and also time to determine my client, determine the course of trial, whether shall first expand on evidence on who's been going more witness.
How long do you want to prepare? 1 day, 10 days, 3 days? How many? You know, we have to continue, and this is, as the council appears in this matter, you know. But briefs, you know, it is a continuous process. You don't have a lot of time.
You know, like prayer to by 6 and be ready.
6.
By 6.
We are put it to tomorrow, but it will not be possible. Who is that one? Huh? Yeah, the prayer. What is your prayer? You can talk, I can hear you.
Oweekitiibwa omulamuzi, nsaba kkooti embeerera ya kisa enkyusizeemu ku pulizoni gye yansindika olw'ensonga nfuna okutiisibwatiisibwa nga bwe nakiteeka mu sitatimenti yange okwagala okunzita. Nze Kiseka Hassan. Kasolo n'ono munne be bantiisatiisa era nga nakiteeka.
Now, Mr. Serwanga, they are like a conflict. I think we are giving you a lawyer as well. Do you have any problem with Mr. Serwanga? Because this everything is represented by who? By Mr. Serwanga. So there's no way the same people can go. The other is representing Mr. There's no problem. But this one here. So in that case, can we get you another lawyer so different from Mr.
Tewali buzibu Oweekitiibwa omulamuzi, naye mbadde nsaba kkooti embeerera ya kisa enzigyayo ku pulizoni olw'ensonga obulamu bwange buli mu matigga. Kasolo ne munne Rasita. Lubega Johnson.
Who is arranged? I'm not sure. I'm not looking where into that. The prison authorities can know when that happens.
Gambangako ku kintu kyonna era kkooti ne banga eyagala okufuna kujuza obusingawo awo Omafa prison bwegali. Ensonga ey'okubiri Oweekitiibwa omulamuzi, wali otusuubiza okutuwaka ku ruling ya submission ya no case to answer nze ne lawyer oyo, naye simanyi oba ye wagimuwa naye nze sinnagifuna. Ensonga ey'okusatu Oweekitiibwa omulamuzi, nsaba kkooti Oweekitiibwa omulamuzi emanye kubanga omwami oyo Kalyango tuli ffenna wano mu ddooko tusobola obbanga kkooti egenda mu maaso natandikirawo era okukuba enduulu n'agamba nti mugambye ebigambo by'okumutta. Nsaba kkooti omulamuzi benga ekimanyi ekyo kubanga ekigendererwa kyabwe kinene n'oludda oluwaabi. Namwe Oweekitiibwa omulamuzi bwe kibeera nga kisoboka nga si kulagira ala bwe kiba nga kisoboka Oweekitiibwa omulamuzi, kkooti bwe beesobola okufuna weemuteeka oba nze ne bafuna we banteeka oba si kyo ne balagira ku bakamu baffe bana ba pulizoni oba najja n'abeerawo awo mwaneeno nga baasobola okujulira. Kyembadde nsaba kkooti Oweekitiibwa omulamuzi zezo ensonga zange naye ng'esooka eri ane nsaba Oweekitiibwa omulamuzi eteekebwe ku likodi nti nze simugambangako eteekebwe ku likodi y'omusango guno tesimugambangako. Yes, era Oweekitiibwa omulamuzi omulane bwabe Oweekitiibwa omulamuzi ensonga yange esooka egamba Kalyango Nasifu Alliance Muwonge Alliance Muwonge
If there was a case with whatever, you will be taken to a magistrate's court for trial. So that one is not important here.
Tewali buzibu Oweekitiibwa omulamuzi, naye mbadde nsaba Kkooti embeerera ya kisenzi enzigyayo ku Upper Prison olw'ensonga obulamu bwange buli mu matiga. Kasolo ne munne Rasita. Lubega Johnson.
Yes. You know, last time when that was raised by the other one, I said that it is the prisoners' authorities, as they have done for the other one, they should do that for the other. This is within the domain of what? Of the prisoners. Please, the man has made a request in open court, as you did for the other one without being directed by me. I hope you will also do for the other one. Have you heard? Okay, please. It is urgent to the sick.
Case number 31, 2022, Uganda versus Kiza Alice. Jadi apa?